Well, thanks for coming in today, Rodney. Understand you want to know a little bit about the adjudication process?
I do, Graham. I'm a financial director of EasyBuild Limited. I know it's one of your best clients, but I've got no knowledge of the building industry, really. I was mainly in factoring and building supplies, so this is a bit of a change to actually the construction. So
Yes.
we've got some outstanding debts, and some of them are quite huge. And what I want to know is the best way to get these debts in, and I've been told adjudication is one of the good ways of quickly getting a result.
It certainly is, Rodney. What areas in particular on adjudication were you...
Well, and this might again sound stupid, Graham, it's starting off, what do I need to know about adjudication?
Yes.
And when can I refer a dispute to adjudication?
Yes, well, that would depend upon your contract. There are two ways in which you can refer matters to adjudication. The first way is if your contract itself says that the dispute resolution procedure can be adjudication. And secondly, if you have what's called a construction contract, which effectively, Rodney, means the usual conceptual things of construction, i.e. building, extending properties, etc. In the usual construction supply, if you have a construction contract, then under an act called the Housing Grants and Construction and Regeneration Act 1996, adjudication as a dispute resolution procedure is automatically implied into the construction contract.
Are there any exceptions to that where we couldn't adjudicate?
Yes, there are. There are some exceptions. In particular, contracts that you may have relating to the oil industry or natural gas or the nuclear industry. And actually one important exception is where you are carrying out work for a residential occupier. It's where you're carrying out work on their property that they intend to live in. That's an exception.
Well, that's good, 'cause that's about only 1% of our actual turnover.
Good.
What are the key points for me as a director to consider whether we go to adjudication or not?
That would depend upon several things. Firstly, the value of your claim. If it's a small claim in terms of value, for example, something like £5,000, then it's not worthwhile going to adjudication simply because you can't recover any of your legal costs in that process, and you'll probably spend more than that in terms of your lawyer's fees or experts' fees in actually progressing the matter to adjudication. Also, it usually isn't the correct procedure for very complex disputes, simply because there's a fairly truncated time limit, usually 28 days.
Okay, I think I understand that. I understand about the fees, but who pays the adjudicator's fees?
Well, the adjudicator has a discretion which he will exercise at the end of the day, depending on his award. So I've had situations where the adjudicator has split the fee 50-50. Usually the winning party, the losing party is required to pay the adjudicator's fees.
I think I've got a handle on that now. So how do you go about adjudicating then? What's the difference between a dispute, a genuine dispute, or adjudication?
You have to have a dispute that the good old legal terminology is the dispute must have crystallised. In other words, the parties must have a genuine dispute and recognise that there is a genuine dispute. If the parties are still exchanging correspondence and there are still further information required, then the dispute may not have crystallised as such. So you have to recognise both parties that they are in dispute in order to refer it to adjudication.
Great, because we've got two at the moment where I think there is a dispute. We've just hit a brick wall.
Yes.
And we're just not getting paid, no correspondence from the other side. Is there any way people can stall adjudication to buy more time?
Yes, there is. As I mentioned, it links on to your previous question, Rodney, which is where you require further information. So in fact, what you can do is to indicate to the other side that there is not a dispute at present because you're seeking further information, perhaps a breakdown of their claim, how they get to the sum that they're seeking. So yes, you can buy more time by asking for some more information.
Well, great. And the two claims we've got, that isn't the case because we've gone through everything now.
I understand that you require a little bit more information about the adjudication process in connection with these matters that you've currently got.
I've just made some notes mentally that I just want to run through with you, just so I understand about what goes in a notice of adjudication.
Yes.
And how you appoint adjudicator.
Yes.
So if you don't mind, I want to grill you again.
Yes, certainly.
What does the notice have to include by way of detail?
Yes, I mean, the notice of adjudication can be a fairly simple notice containing simple information, but it must contain the names and addresses of the parties, the nature of the dispute, where and when the dispute arose, and basically what relief you are seeking. So those are the basic information that must be contained in the notice.
Right. What happens if we miss out part, or there's a part that I'm told later on, as it is happening now, can we add this in, can this come in?
No, if actually, although the information is basic, it must contain that information. If it doesn't contain that information, then effectively the notice is void. Also, you have to include in that notice everything that you would be seeking to claim in the referral document, which is another document you must serve later on.
Okay. Now, say that the trick works, we threaten adjudication. What happens if we start on the process but we want to stop it?
Actually, a lot of solicitors use this as a tactic. You can serve your notice of adjudication and then allow it to lapse.
Yeah.
There's no legal obligation once you've served the notice of adjudication to go through with it. You can, in fact, allow it to lapse. What that usually does is the fact that you've served the notice indicates to the other side that you are actually intending to progress matters formally, and it quite often opens a dialogue.
Okay, that comes on my next question then. If we're adopting that sort of tactic, when do we have to appoint adjudicator?
You do have to appoint an adjudicator within 7 days of the service of your notice of adjudication. If it goes beyond the 7 days, then again you'd have to serve the notice again. It would lapse.
Right. Who can be appointed as adjudicator? Does it have to be a qualified building surveyor or chartered surveyor?
Normally, Rodney, quite often the parties indicate in the contract the person that they wish to appoint if there is a dispute as an adjudicator. Sometimes, if you don't name the person, it actually specifies the adjudicator nominating body known as the ANB.
Right.
So you can either go to the person named or to the ANB, or if neither of those things apply in your contract, you can agree between the parties.
Right, so this AMB then, how do they tell us then? How do they come back to us, or do they come back to you and say, look, we decided that A or B is going to be appointed?
Yes, what you do is you, if the contract, for example, names the RICS, the Royal Institute of Chartered Surveyors, as the ANB, you fill in a simple form,
Okay.
send in a fee, which I think is about £380 for the RICS. They then must nominate an adjudicator within 5 days. So they then inform you who the adjudicator is,
Okay.
and then usually you hear from the adjudicator himself.
Well, that's really helpful, Graham. I'm glad you explained everything to me. But this is part of a learning curve for me.
Fine.
But it's just so I get to grips with the procedure, because
Yes.
it's quite new to me. Now, you've mentioned in your last email about referral notice, and can you just explain what that is and what I have to do by way of information?
I will, Rodney. Having served your notice of adjudication, the next step is then the formal presentation of a referral document. The referral document has to include everything you're seeking to claim. So it's the relief you're after, the supporting documentation upon which you rely, and any other relief, for example, if you were seeking extensions of time, etc., any other relief that you were seeking. So there's no set format for the referral document as such, but it should, because usually adjudication is decided by way of a paper exercise, it should include everything that you're seeking to rely upon and what you're seeking to claim.
One of my friends who is a building surveyor said that it's very important in this referral document
Yes.
to state what discretion an adjudicator has, which I have to say I'm completely lost. I was nodding away when he was talking to me.
Perhaps
Can you explain that?
I can, Rodney, hopefully clarify that for you. The jurisdiction of the adjudicator is decided by the notices that you give him, which is the notice of adjudication and the referral notice, which must be consistent. If you ask the adjudicator for a specific thing, for example, you said, please award us £10,000, then there is an argument to say he has no jurisdiction beyond that sum.
I understand.
So you would say award us £10,000 or such other sum as you think is due and owing. That's the jurisdictional point. That's where he has.
Right.
You've got to give him some discretion.
The other issue I've got is that some of the items are quite large and some are quite small.
Yes.
Can we cherry pick?
That's one of the beauties of adjudication. You can, in fact, pick out a particular aspect of the dispute and simply adjudicate on that element. So if you have 6 elements that you're claiming, for example, if you were claiming loss and expense, usually it derives out of an extension of time. And you could actually decide to pick the extension of time item out and simply adjudicate on that item. And then hopefully negotiations would lead to resolution of the money side.
Yeah. Now, the other thing I'm interested in is, because I've been involved in court proceedings, I've got quite a large amount of experience there, Graham, but what happens at the adjudicator's hearing? Are people called to give evidence?
Well, usually, Rodney, because it's a 28-day period normally from start to finish, so from the appointment of the adjudicator to his decision is a 28-day period.
Oh, really?
Yes, it is. It's very short. And usually it is, because it's such a short period, usually the adjudicator doesn't call a hearing. He simply decides matters by way of a paper exercise. So it's not often that he will call the parties together and cross-examine, etc., as you would in the court hearing that you were involved in, simply because there isn't time. It's done on paper.
Okay, I'm a bit of a control freak, and that's what they said at work. And I like to have things organised and ready so we don't miss anything.
Yes.
When should the referral document be prepared? Can you do it when you're doing your notice?
Well, I would always advise clients, Rodney, to prepare the referral document before you start the adjudication process.
Oh, right.
Simply because as soon as the adjudicator is appointed, on day one, he can ask for that referral document.
I see.
So if you haven't prepared it, you could shoot yourself in the foot.
That could be a nightmare.
Absolutely.
Well, I'm glad you explained that to me, because that would have been a huge pitfall.
It would.
I think I've got to grips with that. Can we ever challenge adjudicator's decision?
You certainly can. What you can't do, you can't appeal against an adjudicator's decision. But I mentioned earlier in response to one of your questions, Rodney, about a jurisdictional point.
That's right.
The adjudicator must follow the procedures, either indicated in the contract itself, which sets out time limits, etc., or under the scheme to the Construction Act. He must follow those procedures to the letter. He mustn't exceed his jurisdiction. If he does, then although you can't appeal against his decision, you can raise what's called a jurisdictional challenge,
Right.
which is considered by the courts.
What's this effect of this jurisdictional challenge then?
Yes. If, for example, the adjudicator was required to publish his decision within 28 days and he took 35 days, then he's exceeded his jurisdiction.
Oh,
He
right.
hasn't followed the procedure. You can then apply to the court, and effectively the court will declare the whole process null and void.
Oh, I don't want that to happen.
Exactly.
I think I've got the timetable. So from start to finish, it can be 28 days.
It can.
Can it ever be more than that?
Yes, it can. Strangely enough, if you are adjudicating under the scheme rather than under the provisions of your own contract, under the scheme, the adjudicator can have an extension for his award of 14 days if granted by the referring party, or it can be extended if both parties agree to any period.
Okay, well, that's been really helpful, Graham, because I think I've got to grips with it now. If you could send me an email due to the bullet points, because
Certainly.
I've got to do a report to the directors tomorrow morning.
I'll be pleased to do so, Rodney.
Okay,
Thanks
thank
for
you,
coming
Graham.
in today.
Well, no, thank you, Graham.
In this session, we learned whether adjudication is appropriate or indeed applicable for a contract, and what exceptions exist to the general rule that adjudication is available in all construction contracts. We also learned how to draft the notice of adjudication and gave guidance on the appointment of the adjudicator. Finally, we learned how to draft the referral notice and the importance of adhering to the strict timetable involved. In the next session of the programme, we will deal with the responding party's response, the adjudicator's decision, and enforcement of that decision.